Hello everyone, this is to welcome you to the 8th edition of Legal Insight. Today is Friday, the 6th day of March 2026. In this edition of the program, we are going to continue our discussion on incorporated companies by specifically looking at meetings of companies. Now one may ask, how many types of meetings do we have? There are actually 4 types of meetings, and they are as follows. First one, statutory meeting, followed by annual general meeting. The third one is extraordinary general meeting, and then the fourth one is board meeting. We are going to consider these types of meetings one after the other. To begin with statutory meeting. A statutory meeting is a type of meeting that is only peculiar to public companies. Private companies are not required to hold statutory meeting, but for a public company, it is mandatory to hold statutory meeting within 6 months from the date of incorporation of the company. The purpose of statutory meeting is to consider, among other things, statutory report. A statutory report is a submission containing information on several aspects, such as allotment of shares, what has been paid in respect of the shares, whether those who acquire shares of the company have actually made full or part payment. In addition to that, a statutory report contains information on pre-incorporation contracts. Pre-incorporation contracts are those contracts that are entered into prior to the coming into being of the company or prior to the registration of the company. In addition to that, a statutory report also provides information on the names, addresses, and descriptions of the directors, auditors, and secretary of the company. Furthermore, during statutory meeting, all other matters in relation to the formation of the contract will be considered. Now, this is statutory meeting. The next one we are going to consider is annual general meeting, AGM. AGM is a type of meeting that brings together shareholders or members of the company and the board of directors or directors of the company to transact certain businesses. These businesses can either be special or ordinary. However, it is important to state that the Companies and Allied Matters Act only mentions the ordinary businesses and says any business other than ordinary business is a special business. So now we are only going to concentrate our discussion on the ordinary businesses. The ordinary businesses are as follows. First, declaration of dividend. Now, one may ask, what is dividend? Dividend is the profit made by the company, which will now be distributed to shareholders based on their shareholding in a company. The second ordinary business is presentation of the financial statement of the company. One may ask, what is financial statement? Financial statement is actually a document prepared by the external auditors of a company, giving a true and fair view of the financial status or position or affairs of the company. It contains basic information such as directors of the company, asset of the company, turnover of the company within the financial year, amongst other information. The third ordinary business of the AGM is election of directors in place of those retiring. Now let me explain this point. At the first AGM of a company, all the directors are expected to retire and they may be due for election. Subsequently, at subsequent AGM, 1/3 of the directors are to retire and they may be due for election. That is why it is an ordinary business of the AGM, election of directors in place of those retiring, not appointment of new directors, rather election of directors in place of those retiring. The fourth ordinary business of the AGM is appointment of auditors and fixing their remuneration. The fifth ordinary business of the AGM is appointment of members of the audit committee and disclosure of the remuneration of managers of the company. Now, any other business other than this that we have mentioned are special business of the AGM. The length of notice for AGM is 21 days. However, the law has provided certain flexibility subject to fulfillment of certain conditions. The person who is to chair AGM is the chairman of board of directors of the company. Now, let us consider a situation whereby a meeting has been fixed a certain venue on a certain date and at certain time, and the chairman is not available or is unwilling to chair the meeting. The law provides that the board of directors or members of the board of directors present are at liberty to choose anyone to preside over the meeting if the chairman is not available after an hour. The next thing we are going to consider is effect of failure to serve notice of meetings on a member or shareholder who is entitled to attend meeting. Such failure generally invalidate the meeting, except if the failure is as a result of accidental omission by the person who is, giving the notice. The next type of meeting we are going to discuss is extraordinary general meeting. Now, what is extraordinary general meeting? Extraordinary general meeting simply means a meeting in place of annual general meeting. The last but not the least of the types of meetings is the board meeting. It is meeting of the directors of the company who direct and manage the affairs of the company. The recommended practice is that a company should hold at least 4 board meetings in a year. That means 1 board meeting in each quarter of the year. Well, this brings us to the conclusion of this edition of Legal Insight. In the next edition of the Legal Insight, we are going to consider directors of the company, the types of directors, and much more. So stay tuned and thank you for watching. Have a nice day.